The next case to come before the court is State v. Seidowsky. Good morning. All right. Each of you will have 15 minutes to present your arguments, and the appellant may reserve up to 5 minutes for rebuttal.
May it please the court, my name is Attorney Joseph F. Salzgeber on behalf of defendant appellant Jeffrey Seidowsky. I'll reserve the balance of my time, though I don't expect that this argument will take the full 15 minutes. This matter arose as a domestic violence charge following a mutual argument and fight between my client Jeffrey Seidowsky and his then-girlfriend Jamie Ivano. They were an unmarried couple living together at a leased residence here in Medina, Ohio. They lived together for approximately 8 months. Mr. Seidowsky also cared for his teenage son. They had recently purchased a boxer puppy, and when the puppy was having house training issues, Mr. Seidowsky apparently spanked the puppy for an accident inside the residence. That led to a verbal argument and then a subsequent physical altercation in which both Mr. Seidowsky and Ms. Ivano hit one another. There was a report to the Medina City Police which resulted in the charge. Mr. Seidowsky ultimately pled no contest to a domestic violence charge, and 2 lesser charges were dismissed pursuant to a plea deal with the prosecutor. Our argument in this case was that the trial court erred and abused its discretion in sentencing Mr. Seidowsky to the maximum jail term of 180 days without consideration of all the sentencing factors under 29, 22. The standard of review is abuse of discretion under this court's opinion in State v. Jones and related case law. In this particular instance, the record essentially indicates that the court only considered the prior record of Mr. Seidowsky in imposing the maximum sentence, where that sentence was not supported by the PSI. There was no indication that this was a more serious offense than other offenses. There was no indication that the victim sought medical treatment as a result of the altercation. Mr. Seidowsky apologized, took responsibility for his actions. He advised the court that drug addiction was the main factor in the offense, and that he had started using drugs again after 6 months of sobriety, well incarcerated for 23 days during the pendency of the case. He again started participating in AA, got a sponsor, and began addressing his issues once again. He had a place to live, or has a place to live with his father in Medina once he was released. Based on the foregoing, the lack of any indication on the record that the trial court considered anything other than his prior offenses rather than the other factors under 29, 29, and 22, we would ask that this court reverse and remand for resentencing with instructions to consider non-residential community control. And I would reserve the balance of my time.
Do we have the PSI in the record?
Yes, it was supplemented in the record. Okay. I recall that very specifically because there was some difficulty in locating it and getting it certified from the municipal court over to the Court of Appeals, but that was accomplished, and that was pursuant to this court's own order.
Thank you.
Thank you.
May it please the court, counsel, good morning. John Quillen, City of Medina Law Department, on behalf of the appellee. This particular, the history of this particular appeal would reveal that there were 2 different lawyers in addition to Mr. Salzgeber that looked upon this and chose to go the Anders brief route. But Joe Salzgeber didn't do that because he's a good lawyer. He really is. And I've been in this position when you look at a transcript and you say, holy mackerel, what am I supposed to do with this? But you try. You try your best. And he did that, and I admire him. I'm not teasing. That's a good job, and I appreciate what he did. He stretched as far as he could, but I don't think he stretched far enough. because the trial court sentenced the defendant within the guidelines of a first-degree misdemeanor, 180 days credit time served. The allegation is that the judge didn't look at all of the factors that he ought to have looked at. There's nothing in the record that says he didn't look at them. He didn't say he looked at it. There's nothing in the record that says he did. I think there is a presumption of regularity that inures to the benefit of the trial court when one tries to judge what it did from afar. It's my understanding that the judge did review the pre-sentence investigation, which included the history of the defendant, and he had heard the allocution at the sentencing, which would have talked about the good things of that he had done. And the court, one would presume, weighed the factors towards a sentence and against a sentence. And he says he looked at the PSI, and he did recite the criminal history on the record. And then he made his decision. I would suggest that that's what judges do. They make decisions and they weigh factors, both pro and con, and they decide what is or isn't needed, and they decide what is or isn't an offense that warrants the maximum sentence as far as jail goes. I think that you just don't have enough as an appellate court to second-guess Judge Chase on this. I don't think you find abuse of discretion. I think you find discretion, and that's different than abuse of discretion, I suggest. And I would ask the court to affirm that trial court. Thank you.
Thank you.
Oh, I'm sorry. I'm trying to make sure that this is the right case. Is this the case where perhaps it was in the victim impact statement where the victim indicated that Mr. Seidowsky had threatened to kill her on more than one occasion?
On the night in question, yes. I don't know about more than other occasions.
No, I meant on that.
There is that allegation.
Okay.
Thank you.
Nothing.
Thank you. Thank you both for your presentations to the court. The court will take the matter under advisement and send a written opinion to both sides. And also, you can look on the court's website. Thank you very much.